Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Stalking Lawyers, Chicago, Illinois. Being charged with stalking in Chicago, Illinois is a serious issue. Stalking allegations can arise from a wide range of situations, but regardless of the circumstances, a conviction can carry severe felony penalties, including jail time, fines, and long-term restrictions that impact your personal and professional life. If you're facing stalking charges in Chicago, Illinois, it's critical to act quickly and secure experienced legal representation. The criminal defense attorneys at Combs Waterkotte have decades of experience handling complex cases and are prepared to help you build a strong defense against your Cook County stalking charges. Call 3-125-00-HELP today to discuss your case and start protecting your future. Stalking Lawyers in Chicago, Illinois, serving all of Cook County. Stalking charges in Chicago and throughout Cook County can escalate quickly, and prosecutors often pursue these cases aggressively. Allegations may be based on misunderstandings, misinterpretations of communication, or heightened emotions, but the consequences are very real. That's why having a skilled criminal defense team on your side is essential from the very beginning. At Combs Waterkotte, we take a strategic, client-focused approach to every stalking case we handle. Our attorneys conduct a thorough review of the evidence, including digital communications, witness statements, and law enforcement reports, looking for inconsistencies and weaknesses in the prosecution's case. From there, we build a tailored defense strategy aimed at reducing or dismissing stalking charges whenever possible. We're prepared to negotiate firmly with prosecutors, but we also approach every case with a trial-ready mindset. If your case goes to court, you'll have an experienced legal team ready to fight for your rights and your future every step of the way. If you're facing stalking charges in Chicago or anywhere in Cook County, don't wait to get the defense you need. Contact Combs Waterkotte today at 3-125-00-HELP or reach out online to schedule your free, confidential consultation. Stalking meaning in Chicago. Under Illinois law, there are 3 particular stalking offenses for which Chicago and Cook County residents may be charged. Stalking, aggravated stalking, cyberstalking. The standard stalking offense is outlined under 720 ILCS 5/12-7.3. The statute goes into detail about stalking, defining the offense as knowingly engaging in a course of conduct directed at a specific person knowing that the conduct would cause a reasonable person to fear for their safety, or suffer from emotional distress. Knowingly on at least 2 separate occasions following another person or surveilling them and threatening bodily harm, sexual assault, or confinement or restraint. Placing a person in reasonable fear of bodily harm, sexual assault, or confinement or restraint. Making threats that are part of a course of conduct while being aware of the threatening nature of one's actions or speech. The same statute also says that someone who has been convicted of stalking once may be charged again if they follow or surveil the same person for which they were originally convicted of stalking, threaten that person or one of their family members with bodily harm, sexual assault, or confinement or restraint. Illinois' aggravated stalking statute covers stalking crimes that have additional severe circumstances around them. 720 ILCS 5/12-7.4 says someone in Chicago or Cook County commits aggravated stalking when they do any of the following during a typical stalking offense: cause bodily harm to a victim, confine or restrain a victim, violates a temporary restraining order issued to protect the stalking target. Finally, Illinois also has a cyber stalking law on the books which essentially covers stalking that takes place in an electronic environment, with a few nuances. The statute, 720 ILCS 5/12-7.5, defines cyberstalking in Cook County and Chicago as engaging in a course of conduct using electronic communications directed at a specific person when the offender knows their conduct would cause a reasonable person to fear for their safety or the safety of another, suffer other emotional distress, harassing another person through electronic communications on at least 2 separate occasions, and threatens bodily harm, sexual assault, or confinement or restraint, places their target in reasonable fear of bodily harm, sexual assault, or confinement or restraint, knowingly and without justification installs monitoring software or spyware on an electronic device to harass a person, and threatens bodily harm, sexual assault, or confinement or restraint, places their target in reasonable fear of bodily harm, sexual assault, or confinement or restraint, creates a web page accessible to at least one or more third parties for a period of at least 24 hours, which contains statements harassing another person that communicates the threat of bodily harm, sexual assault, or confinement or restraint, places their target in reasonable fear of bodily harm, sexual assault, or confinement or restraint. Penalties for a stalking conviction in Chicago, Illinois. The offense of stalking is always charged as a felony in Chicago and Cook County, Illinois. The felony charge an offender faces depends on which stalking offense they allegedly committed and whether or not they already have a similar charge on their criminal record. Here are the felony charges brought against stalking offenses in Chicago. Stalking. Base level charge, Class 4 felony. Second or subsequent offense, Class 3 felony. Aggravated stalking. Base level charge, Class 3 felony. Second or subsequent offense, Class 2 felony. Cyber stalking. Base level charge, Class 4 felony. Second or subsequent offense, Class 3 felony. An individual may also face restraining orders for a stalking charge or conviction in the Chicago area. A few different types of orders may apply depending on the offense in question. Here are some of the most common. Order of protection. Typically reserved for alleged victims of abuse by family or household members. Prohibits contact, harassment, or proximity to an alleged victim and can grant exclusive possession of a residence. Frequently used when stalking occurs in domestic or dating relationships. Stalking No Contact Order. Specifically designed for stalking victims regardless of relationship. Bars the accused from contact, surveillance, or approaching the victim. Common in cases where there is no domestic relationship but repeated unwanted conduct. Civil No Contact Order. Typically granted for alleged victims of sexual violence, including when stalking overlaps with sexual misconduct. Prohibits contact and proximity. Does not require criminal charges and applies even when the parties have no prior relationship. Workplace Protection Order. Often used when stalking behavior targets someone in a professional setting. Allows employers to seek protection for employees facing threats or stalking at work. Restricts the accused from entering the workplace or contacting any employees. No Contact Order. Issued by a judge during a pending criminal case. Prohibits the defendant from contacting an alleged victim. Violations of a no-contact order can lead to additional criminal charges and escalate stalking cases to aggravated stalking offenses. Criminal defense strategies against Chicago, Illinois stalking charges. Because they're always charged as felonies in Chicago, stalking charges need to be taken very seriously. At Combs Waterkotte, we've defended Chicago clients against stalking charges in the past, and we've found the following criminal defense strategies to be helpful in these cases. Lack of intent to cause fear or emotional distress. One of the most effective defenses to Chicago stalking charges is demonstrating a lack of intent. Illinois law requires that the accused knew or should have known their conduct would cause fear or emotional distress. If the behavior was misunderstood, accidental, or benign in nature, like repeated but non-threatening communication, this defense may apply. Establishing innocent motives, such as attempting reconciliation or resolving a dispute, can undermine the prosecution's claim that the conduct rose to criminal stalking. Consent or mutual communication between parties. Chicago and Cook County stalking charges often hinge on whether contact was truly unwanted. If an alleged victim engaged in reciprocal communication, responded positively, or otherwise consented to ongoing interaction, the defense can argue the conduct was consensual, not harassment. Evidence such as text messages, social media interactions, or prior relationship dynamics can show the communication was mutual. This defense is particularly relevant in cases involving former romantic partners where boundaries may not have been clearly established. False allegations or exaggerated claims. In some cases, stalking accusations stem from personal disputes, custody battles, or attempts to gain leverage in another legal matter. The defense may focus on exposing inconsistencies in the accuser's statements or highlighting motives to fabricate or exaggerate claims. By carefully analyzing timelines, communications, and witness testimony, an attorney can challenge the credibility of the allegations. Demonstrating that events did not occur as described can create reasonable doubt and weaken the prosecution's case. Alibi and lack of presence at key times. Because stalking charges in Chicago and Cook County require a course of conduct involving repeated acts, establishing that the defendant was not present during alleged incidents can be a strong defense. An alibi supported by surveillance footage, digital location data, or witness testimony may show the accused could not have engaged in certain behaviors. If enough alleged incidents are disproven, the prosecution may fail to establish the required pattern of conduct. This defense is especially useful in cases involving claims of physical following or surveillance. Insufficient evidence of a course of conduct. Illinois stalking laws require proof of at least 2 qualifying acts directed at the same person. The defense can argue that the prosecution has failed to establish this legally required pattern. Isolated incidents, vague allegations, or conduct that does not meet statutory definitions may not qualify. By narrowing the scope of alleged behavior and challenging weak or unsupported claims, a defense attorney can argue that the legal threshold for stalking has not been met. First Amendment and protected speech issues. Some stalking cases in Chicago, especially cyberstalking, raise questions about protected speech. The defense may argue that the alleged conduct consisted of lawful expression, not true threats or harassment. Courts must balance free speech rights with victim protection, and not all offensive or persistent communication is criminal. If the statements lack credible threats or do not rise to the level of harassment defined by statute, this defense may limit or defeat the charges via the First Amendment. Fourth Amendment violations. Digital stalking cases often rely on evidence from phones, computers, or online accounts. If law enforcement obtained this evidence without a valid warrant or exceeded the scope of a search, the defense can move to suppress it under the Fourth Amendment. Excluding key digital communications or location data can significantly weaken the prosecution's case. This strategy focuses on constitutional protections and may result in critical evidence being deemed inadmissible in court. Entrapment or law enforcement inducement. In rare cases, Chicago stalking charges may arise from undercover operations or law enforcement involvement in online communications. If officers or agents induce the defendant to engage in conduct they otherwise would not have committed, an entrapment defense may apply. The focus is on whether the criminal idea originated with law enforcement rather than the defendant. Successfully raising this defense can lead to dismissal if improper inducement is proven. What to do if you're arrested for stalking in Chicago, Illinois? If you're arrested for stalking in Chicago, what you say or do in the hours or days after your arrest can have a direct impact on your case. The expert criminal lawyers at Combs Waterkotte recommend the following steps for anyone accused of stalking in the Chicago or Cook County area. Remain silent and avoid answering questions. Anything you say can be used against you in a stalking case, especially statements about communications or intent. Politely decline to answer police questions until your attorney is present to avoid unintentionally strengthening the prosecution's case against you. Request an attorney immediately. Asking for a lawyer invokes your constitutional rights and stops police questioning. An experienced Chicago criminal defense attorney can guide you, prevent damaging statements, and begin building a defense strategy tailored to Illinois stalking laws and your specific situation. Do not contact the alleged victim under any circumstances. Even if you believe the situation is a misunderstanding, contacting the alleged victim can worsen your case significantly. It may violate bond conditions or protective orders and could elevate charges to aggravated stalking, leading to more serious criminal penalties. Comply fully with any protective orders. If a court issues an order of protection or no contact order, follow it strictly. Violations can result in additional criminal charges and significantly harm your defense, even if the underlying stalking allegations are later challenged or dismissed. Preserve all relevant communications and evidence. Save text messages, emails, call logs, and social media interactions that may show context or mutual communication. This evidence can be critical in disputing claims of harassment, lack of consent, or intent to cause fear or emotional distress. Avoid discussing your case with others. Conversations with friends, family, or on social media are not protected and can be used as evidence. Prosecutors may use these statements to establish intent or contradict your defense, so limit discussions strictly to your attorney. Document your whereabouts and interactions. Create a clear timeline of events, including where you were and any interactions with the accuser. Supporting evidence like receipts, GPS data, or witness statements can help establish an alibi or challenge the alleged course of conduct. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.